Hi guys, and welcome to part 2 on the discussion on dissolution, winding up, and termination. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Also, a like on my videos would be greatly appreciated. Okay? So let's begin with part 2, and we'll begin with the rights of a partner upon dissolution. Okay? First, let's talk about a rightful dissolution, meaning that there is no contravention of the partnership agreement. Okay? The partnership contract was not violated. Okay? So in case of a rightful dissolution, then of course a partner has the right to receive what is known as a partner's lien. Okay? First, he has the right to have partnership property applied to discharge partnership liabilities, and second, he shall receive in cash his share of the surplus. Okay? Now, of course, this is subject to a contrary agreement, and in the case of an expelled partner or a partner who was expelled from the firm, he shall receive in cash only the net amount, okay, the net amount due to him from the partnership. Okay, and if dissolution is proper, then no partner is liable for any loss arising from the dissolution. Okay, other losses, of course, he will be liable, but losses arising from the dissolution, no. Okay? Now, in case of a wrongful dissolution, no, the dissolution was wrongful, no, or in contravention of the agreement, then first, these are the rights of the partner who did not cause the wrongful dissolution, meaning the rights of an innocent partner. Okay? First, to have partnership property applied to partnership liabilities. Second, to receive in cash his share of the surplus, and third, to be indemnified for damages caused by the partner who caused the wrongful dissolution. Okay? Fourth, to continue the business in the same name during the agreed term of the partnership, either by themselves or jointly with others. And fifth, to possess partnership property if they continue the business. Okay? Now, let's go to the rights of a partner who did cause. He was the one who caused the wrongful dissolution. Okay? Now, this has two scenarios. No? So first, if the other parties do not continue the business, no, meaning you caused the wrongful dissolution, ayoko na, quits na. Okay? Then his right will be to receive only the partner's lien. Okay? In other words, to apply the partnership property to the liabilities and to receive in cash his share of the surplus, less we subtract the damages he is liable for because of his wrongful dissolution of the partnership. Okay? Second scenario, if the other partners continue the business, then the right of the partner who caused the wrongful dissolution would be to have the value of his interest in the partnership at the time of the dissolution and the surplus less subtract damages caused by his wrongful dissolution ascertained. Okay? We determine now what is the value of his interest in the partnership and his surplus less damages. No? Ano yung value nun? Okay, and after it's ascertained, to have that paid to him or secured by a bond approved by the court. Likewise, he is also entitled to be released from all existing and future liabilities after, of course, he pays the damages. No? Take note that the goodwill of the business is not considered in ascertaining the value of the interest of the guilty partners, because goodwill is property. No, you can ascertain its value and receive the monetary equivalent of that. That's not included for the guilty partners. Okay? Now, a partner may have the contract of partnership rescinded. Okay? Remember, I discussed this earlier. No, failure to contribute the property or money promised is not a ground for rescission. The only time that rescission may be had in partnership, the remedy nga pala in the first place, no, failure to contribute the remedy there is specific performance. Here, rescission can only exist, no, in favor of a partner if he was induced by fraud or misrepresentation to become a partner. Okay? In such a case, the contract of partnership is voidable, and the partner can have that contract of partnership annulled. If he succeeds in having that contract annulled, okay, then, and in the case of annulment of that contract of partnership, then that partner will be entitled to restitution. Okay? Meaning he will get what he has given, no? As a consequence, of course, of rescission, no? Remember also that in the case of voidable contracts, no, these contracts are valid until they are annulled. Okay? And in the case of a partnership, the partnership relations exist until the contract is annulled. So therefore, the defrauded partner is liable for all obligations to third persons, no? Because before he has the contract of partnership annulled, he was a partner. The contract was valid. So while it was valid, the contract was valid and obligations were contracted, then he will be liable for those obligations. Okay? In case the contract of partnership is rescinded on the ground of fraud or misrepresentation, the rights of the partner who asks for rescission are as follows. First, the right of lien. Okay? Lien on or retention of the surplus of partnership property after satisfying partnership liabilities for any sum of money paid for the purchase of an interest in the partnership or for any capital or advances contributed by him. Second, the right to be subrogated in place of partnership creditors after payment of partnership liabilities for any payments he may have made, no, for those partnership liabilities. And third, the right of indemnification by the guilty partner against all debts and liabilities of the partnership. Okay? So now we can move on to the winding up process, no? And what is winding up? It is simply the process of settling the business or the partnership affairs after dissolution. Okay? Now, winding up can be judicial or extrajudicial, and in the process of winding up, the business of the partnership is not continued, Okay? Instead, the process of winding up consists of reducing the property to cash and distributing the proceeds. In other words, the property must be liquidated and distributed to those entitled thereto. Now, partners have the implied authority to sell partnership property and collect obligations due to the partnership, but this authority may be delegated to one or more partners who will be known as the liquidating partner or partners. Okay? Now, of course, the persons authorized to wind up are either the partners designated in the agreement, no, the contract of partnership. But in the absence of an agreement, then those who have not wrongfully dissolved the partnership or the legal representative of the last surviving partner who is not insolvent. In other words, the law says that first, in the absence of agreement, the partners who have not wrongfully dissolved the partnership or the legal representative of the last surviving partner who is not insolvent, they have the right to wind up the partnership affairs. Second, but if there is an agreement, it is the partner stated in the agreement who has the right to wind up the partnership affairs, and others, no, the other partners have no right to participate in the settlement of partnership affairs. Okay? So if partnership affairs are settled by a partner who had no authority to wind up, then the partnership is not bound by his acts, except of course if he transacted with a third person who had extended credit and had no knowledge of the dissolution, or if he had transacted with a third person who, despite having had no knowledge or notice of dissolution, is charged with constructive notice through advertisement in a newspaper of general circulation in the place of business. Meaning the third person is in good faith. Okay? Remember also that under 1842, a partner has the right to demand an accounting of his interest, okay, in the partnership against the partner in charge of winding up, or against the surviving partners, or those continuing the partnership as of the date of dissolution, except of course if there is an agreement to the contrary. Okay, so what are the powers of a liquidating partner? First, he can make new contracts but for liquidation purposes only. Second, he can raise money to pay partnership debts. Third, okay, he can incur obligations to complete existing contracts or to preserve partnership assets. Fourth, he may incur expenses necessary in the conduct of litigation, no, meaning case in court. Okay, so what are the assets of the partnership? No, first, of course, the partnership property, no, including the goodwill, and second, the contributions of the partners necessary for the payment of all liabilities. Remember that the partnership obligations will be satisfied out of partnership assets before the separate property of each partner may be proceeded against. Now, this is the order, okay? The order of payment when it comes to winding up, okay? First, you pay those liabilities owing to creditors who are not partners, okay? Those owing to creditors other than partners. Second in line, no? Those owing to partners other than for capital or profit, okay? Third, those owing to partners in respect of capital. And finally, those owing to partners in respect of profits, okay? Now, if the assets of the partnership are insufficient, meaning there is an overall loss, no, then the deficit is a capital loss which requires contribution, just like any other loss, meaning the partners have to contribute to meet that loss, no? So the partners shall contribute the amount necessary to satisfy the liability according to the agreement, no? They have an agreement, no? If they have an agreement, okay? An agreement as to the distribution of profits and losses. But if there is no agreement to follow, no, they did not make one, then of course, pro rata. And this may be enforced, no? The liability, no? The liability may be enforced by an assignee for the benefit of creditors, any person appointed by the court, any partner or his legal representative, okay, to the extent of the amount which he has paid in excess of his share of the liability. In case of a deceased partner, his individual property shall be liable for the contribution. Again, now if the assets of the partnership are insufficient, okay? So before the partners can be paid their shares, no, the creditors of the partnership must first be compensated. After all the creditors have been paid, whatever is left of the partnership assets becomes available for payment of the partners' shares. Okay? Since we're on the topic of creditors, let's talk about the rights of partnership creditors and individual creditors. Okay? So when it comes to partnership creditors, meaning remember the partnership has a separate juridical personality different from the partners which compose it. Okay? So the partnership creditors, they enjoy preference over the creditors of each individual partner with respect to partnership property. And individual creditors, no, the creditor of each partner, they are entitled to be paid only out of the individual debtor partners share in the surplus which remains after the firm debts have been paid. In other words, the individual creditor of this partner, no, will have to wait until after the partnership's debts have been paid. Okay? So they have to wait for that, and they have to wait after the equities among the partners have been adjusted, no? And he has to wait also until that debtor partner's share has been ascertained and set apart. Because until the winding up process has been completed, an individual partner will not yet know exactly how much he will be getting yet, no? You have to pay first the liabilities, adjust the equities amongst themselves, And then that's the only time you can determine, I'm getting 1,000 pesos pala. Like that, okay? So with regard naman to the separate property of each partner, no? Again, the partnership itself can own property. Each individual partner can own their own property as well, no? Which they did not contribute to the partnership. With regard to his separate property, it is the individual creditor of each partner that enjoys preference over the creditors of the partnership itself. Okay? Again, partnership has a creditor. They enjoy preference as to partnership property. Okay? An individual creditor can only get the partnership property after the partnership's liabilities have been paid, after the equities have been adjusted amongst the partners, and after each partner's share has been ascertained. But if an individual creditor has a claim against an individual partner, then he has preference as to his separate property, which he owns, not the partnership owns. Okay? Now, if the partnership property and the individual properties of the partners are under possession of the court for distribution, we follow what is known as the doctrine of marshaling of assets, no? This is under 1839 paragraph 9, no? 1839 item 9, no? First, partnership creditors have preference in partnership assets. Second, separate or individual creditors have preference in separate or individual properties. And anything left from either goes to the other. Okay? And this, of course, these rules, no, are subject to the rights of lien of secured creditors. Okay? Like if there's a mortgage, etc. Where a partner has become insolvent, on the other hand, no, or his estate is insolvent, then the claims against his separate property may order din yan, no? First, that which is owing to separate creditors. Then, that's the only time you can satisfy the liabilities owing to partnership creditors. And after that, that which is owing to partners by way of contribution. Okay? Now, I want to talk about 1840 of the Civil Code, no, which speaks of a dissolution of the partnership by a change in membership. Okay? So when a new partner is admitted to the partnership, or when a partner retires, he dies, withdraws, is expelled, or when the other partners assign their rights to the sole remaining partner, or when all the partners assign their rights in the partnership property to a third person, all of these, no, that I just mentioned, these constitute a change in the membership of the partnership. And this change dissolves the partnership and creates a new partnership. Okay? So 1840, it deals with the rights of creditors when the partnership is dissolved by a change of membership. Okay? And also, no, as part of this scenario, it's dissolved by a change of membership, and the business is continued by a former partner, either alone or with new partners, and no liquidation of the partnership has taken place. Okay? In such a case, the law makes the creditors of the dissolved partnership also the creditors of the persons or the partnership which is continuing the business. Creditor ka ng luma, na-dissolve, may bago, creditor ka pa rin ng bago. Okay? If there is no liquidation and it is continued. In other words, both classes of creditors, the old and the new, are treated alike. They are given equal rights in partnership property. And the purpose of the law is to maintain the preferential rights of the old creditors to the partnership property as against the separate creditors of each individual partner. Okay? Preference, no? So, I just want to read the codal, no, of 1840 very quickly, no? Kasi since it's codal, you can do this on your own, no? But just this one time, I'll spoon feed you na rin, no? So, 1840 says that in the following cases, creditors of the dissolved partnership are also creditors of the person or partnership continuing the business. Okay, first, when any new partner is admitted into an existing partnership, or when any partner retires and assigns, or the representative of the deceased partner assigns his rights in partnership property to two or more partners, or to one or more of the partners and one or more third persons, if the business is continued without liquidation of partnership affairs. Okay? Second, when all but one partner retire and assign, or the representative of a deceased partner assigns their rights in partnership property to the remaining partner, okay, who continues the business without liquidation of the partnership affairs, either alone or with others. Also on this matter, please remember that in 1826, the liability of the new or incoming partner shall be satisfied out of partnership property unless there is a stipulation to the contrary. Third, when any partner retires or dies and the business of the dissolved partnership is continued as set forth in the first two paragraphs I mentioned, with the consent of the retired partners or the representative of the deceased partner, but without assignment of his right in partnership property. Fourth, when all the partners or the representatives assign their rights in partnership property to one or more third persons who promise to pay the debts and who continue the business of the dissolved partnership. Okay? So this rule in the fourth item, applies only when the third person promises to pay the debts of the partnership. Otherwise, creditors of the dissolved partnership have no claim on the partnership that is continuing the business or its property unless the assignment can be set aside as a fraud on creditors. Okay? Fifth, when any partner wrongfully causes a dissolution and the remaining partners continue the business, okay, either alone or with others, and without liquidation of the partnership affairs. And sixth, when a partner is expelled and the remaining partners continue the business either alone or with others without liquidation of the partnership affairs. Okay? So just take note that when the business of the old partnership was simply continued by the new partners without the old partnership undergoing the procedures relating to dissolution and winding up, then not only the retiring partners but also the new partnership itself, which continued the business of the old dissolved ones, are liable for the debts of the old partnership. Okay? Now, when the business of a partnership after dissolution is continued under those grounds I mentioned earlier, the creditors of the retiring or deceased partner or the representative of the deceased partner, they have a prior right to any claim of the retired or deceased partner or his representative against the person or partnership continuing the business on account of the retired or deceased partner's interest in the dissolved partnership or on account of any consideration promised for such interest or for his right in partnership property. Okay? Now, the remaining partners, by themselves or with new partners, they can continue the business by simply taking over the business enterprise and continuing the use of the old name without liquidating the partnership, In case of deceased partners, remember I discussed in my other video, just put a cross by the name or indicate in all your communications that he is dead, Take note, however, that the use by the person or partnership continuing the business of the partnership name or the name of a deceased partner as part thereof, it shall not of itself make the individual property of the deceased partner liable for any debts contracted by such person or partnership. Okay? Take note of that. That's caudal, However, the creditors of the dissolved and the new partnership are given equal rights, in the partnership property. Now, under 1841, when any partner retires or dies and the business is continued under the conditions I mentioned earlier, in 1840 or in the case of 1837, meaning wrongful dissolution, without any settlement of accounts as between him, or his estate and the person or partnership continuing the business, then these are the rules, okay? These will be the rules unless there is an agreement to the contrary, The rules are, first, the partner or his legal representative as against such person or his partnership or the partnership, no, may have the value of his interest at the date of dissolution ascertained, no? Alamin yung value ng interest. And second, the partner or his legal representative shall receive as an ordinary creditor, okay? Para siyang ordinary creditor, he will receive an amount equal to the value of his interest in the dissolved partnership with option to either receive interest or, in lieu of interest, the profits attributable to the use of his right in the property of the dissolved partnership. Okay? The creditors of the dissolved partnership shall have priority on any claim arising under Article 1841 as against the separate creditors or the representative of the retired or deceased partner. Okay? So, to sum it all up, no? Just remember na dissolution, winding up, and termination, while they all are part of the last stages of the life of a partnership, these three are different. Okay? Dissolution has to be for the causes mentioned in the law or under the agreement. Can be extrajudicial or judicial. Okay? But partnership will still continue to exist even though it has been dissolved. Okay, because the significance of dissolution is only to put a stop to the partnership relation. Meaning, depending on the rules I mentioned earlier, each partner's authority to act for each other and for the partnership may be terminated. Okay, because the firm is dissolved. However, the separate juridical personality of the dissolved partnership will continue to exist for winding up. Okay? Meaning, this is the process that you should settle na all your obligations, pay them. And then after it's paid, you adjust the equities of the partners and then you give them all the surplus, if any. Okay? And after all that is done, that's the stage of termination. The partnership is now dead. Okay? Okay? So that's it. 3 stages. And that's dissolution, winding up, and termination. So I hope you may have picked up a thing or two. And I hope to see you next time on my episode on limited partnerships. Okay? So, see you soon, guys. Bye.